20 years, because people have a right in it.
Eliot, the question is, are they a named defendant?
Well, that's what I'm trying to say to you. I left with Shinlin, if you read the early documentation in the RICO filing, that, you know, to save space on the letterhead and not include 3,864 people by name, I seek leave to amend that complaint to add all of these people, and I give her the list, and you're on that list.
But just so the reason
Yeah.
I asked the question, I just want to make sure that I haven't missed something. Right. We've never actually been served as a defendant in a complaint.
No, and I did that for a reason, a nice reason. And, you know, I'm not a nice guy, as you can see from the people I included in there. I didn't do that because there were friendships, and not just my friendships, but outside third-party friendships from the legal community, etc., who had brought me into Warner Brothers, such as Armstrong Hirsch and Irella Manella. And I have very deep-seated friends going back 30 years at those firms, and I did not want to put them in any precarious position at this point, although they are investors in my technology, etc. But, you know, at some point, where I said to you, you know, I thought it was a critical mistake to allow that SEC filing to go in. You know, and I think that the quicker you guys write that, the smarter it is. Especially if you know that you're infringing on my technology, you should just basically be paying the right guy instead of the wrong guy, and especially if you know that the wrong guy is stealing my technology too, that makes it really, really, really wrong. And so there's a way to write that, and I'm offering that because of those friendships, but my patience wears thin, and it wore too thin. You know, now we're in the war position that I don't like to be in with people where there was an exit strategy. So again, I'm going to let Mark finish up on, you know, possible exit strategies to this. Notice that I am giving you notice as their counsel that there is anticipated and continued litigation where if no deal is forthcoming as of like this minute, yet like a few minutes ago, days and weeks, that you will be part of all future actions as a defendant. And so you could start actually listing that as a contingent liability and should notify your insurance carrier immediately of that statement. And I've written that statement to your counsels, etc., so, you know, I'm just reiterating it here. And so that we make that point going forward. No, and I would appreciate that you respect why I went through the trouble of putting your name on an exhibit list as a future defendant in the case with Sheriff Shinlin and not a direct defendant, despite your prior blowing me off. But I can deal with that, you know, and because I don't believe you guys were original conspirators in the crime.
What is the current procedural process? It was dismissed, am I right?
It was dismissed, and it will be appealed, and there's a lot of, you see, right now, you know, this is how messy it's going to get, and that's why I don't want to see your name dragged through all this, but the whistleblower came out, and she kind of fingered the internal court proceedings and said that there's been document destruction and witness tampering in federal case. Somebody actually going to give deposition testimony at her case was threatened on the way to her deposition by senior officials of the court. She fingered whitewashing of complaints for U.S. attorneys, district attorneys, and she's fingered the New York Attorney General, who's representing the state defendants in my case as well as the whistleblower case, as conducting illegal representation because of his conflicts. And it's getting really messy and ugly, and so if you really get technical into it, what you'll find is this is going away no time soon either. Meaning, and by the way, on the patent side of life, obviously you can anticipate litigation for the next 20 years, easily. You know what I mean? Of thousands of things where it's going to be coming back to you every time I file an infringement case. And so this isn't going away, whether the court that it's in right now, which is very dirty and has had lots of conflicts and is being exposed, You know, but if you want to go through that and try to hang it out and tell your auditors it's all cool and stuff, that's great, but I'm going to be notifying the general public, et cetera, the entire time of what's going on, and then every single, I think in fact on the last filing maybe I haven't filed it yet, I'm not sure, Kevin will know a little better on that, but I have a filing going in where I've added anticipated future defendants, some of the newer players who came in, and but I do believe I've added your name. After I sent the SEC letter, you know, there obviously was no deal as far as I was concerned, so, you know, I went down warpath.
Elliot, he's trying to ask a question. I can't hear a question. Mr. Howard, give me a little on what the license is. Well, what am I licensing? What are you proposing to grant a license for? My suggestion is we sit down and hammer it out together to give you the broadest reach you would like, because you are in a wonderful position for all kinds of reasons to, and I use this term in the British sense, truly exploited to the full extent. But it's a mathematical scaling process or formula for encoding and playing back video at the most beautiful looking you could get on any device, such as computer, cell phones, what have you.
Television.
Television lowers significantly the amount of bandwidth necessary to support streaming images as well as sound, I believe. Not a technical type. It's you'll see super smooth zoom and pan capabilities when you view images. It creates a high definition and resolution super zoom and pan capabilities without the pixelation and blocking that you see on a lot of screens. It's technology, frankly, you see and use every day. It would be a worldwide exclusive license to make, use, or sell the processes and perhaps even the content. The right to sub-license it is necessary or desirable, obviously within your organization, but more importantly outside. I think it's is there a patent that would underlie this license? Yes, they were purposely put into suspension because the original patent lawyers hired from a very, very large New York-based firm were involved in sabotaging it at the last minute. They literally took out key pages and information, substituted junk for it, and days, weeks later, one of the patent lawyers filed patents in his own name with this technology.
90 patents.
So clear, it's almost laughable. So you have, so no patent is issued and the application has been suspended or confused.
The patents.
Review, not review, it's under investigation.
Here, let me tell you where it was at. Yeah, Mr. Liu, this should interest your patent department because I've included them.
That's an area where we certainly could use your help.
Okay, and here, well, actually, at this point, I kind of like them in the suspension phase. It's kind of like limbo. It's a new art for inventors submarining their patents inside the patent office. I don't think anybody's ever done it before, but it will go down as new. But what happened was I filed complaints against those attorneys Mark just told you about with the United States Patent Office, the Director of Office of Enrollment and Discipline, Harry Motes. Mr. Motes, after reviewing and finding that patents were in the attorneys' names and in the wrong people's names and all kinds of other malfeasances, including filing submissions dating into the 1900s by our patent attorney, he asked me to draft a letter to the Commissioner of Patents citing fraud on the United States Patent Office. Not fraud on Eliot Bernstein and Iviewit, but fraud on the United States Patent Office by our attorneys seeking for suspension of the patents until it could be regaled out through his investigation with a FBI agent who left the FBI to work with the U.S. Patent Office on crimes against the United States. That's my understanding. I filed the document such. I named the attorneys involved. I hadn't named you yet, but I have been lately. And the attorneys involved, for example, Wayne Smith, etc., are being asked to be investigated by the Patent Office with the other people now because of the possible collusion between him and Rubenstein of Proskauer. Anyways, Moats, on that note, got a team of patent experts together inside the Patent Office, and they filled out all of my forms and all answers and any other outstanding issues. They removed all attorneys from the patents, and they moved them to a position where if the commissioner agreed, they would be suspended. Now, normally suspensions are only granted 3 of them over I believe, 3 90-day suspensions or something. I'm not sure what it said, but it was years ago. Anyways, whatever it is, it's 3 of them for a few days. And at this point, after the second request for suspension, the Patent Office has gone silent on me, including not giving me my patent files. But they have suspended the patents, and to the best of my knowledge, the Patent Office and the FBI and possibly others are investigating the criminal allegations that were levied against the lawyers involved in the thefts of the patents. And again, another reason Time Warner should jump up and down and throw the briefcase of money we requested last time at us and get out of this before you become part of that ongoing 20-year nightmare. And again, I hate to see people who are collateral damage get dragged into more crossfire, and I'm trying to give you guys every option out. But last time I asked for the next meeting, which I think Mark can explain to you a little better, $50 million to sit down and discuss this opportunity and draft some language to get you out of here.
I'll put that again.
Well, if you read the documents I sent to AOL, Time Warner, and whatnot, we offered you a meeting, which would have been this. I mean, this meeting should have cost already, but being the nice guy I am not, I offered Mark to do this one free. But on the next meeting, to sit down and talk a license and do all those things Mark was talking about, we're asking for $50 million down and non-refundable, and that will get you to the next level, hopefully, if you find a way that this is better than going the other way. But, either way, I don't really care. That's up to you guys again. I just came here, on this meeting today to offer you the out. On the next meeting, take a look at the documents I sent to your, executive group, and the filing I filed with the SEC has all those documents attached to it.
Well, this is a different situation than all the other players, again, because of not only Eliot's relationships to you folks, but the involvement you folks had from and the interest in the technology that, those dollars Eliot mentioned are chump change compared to the kinds of dollars you folks make from this.
Have made from it.
Really could dominate this field going forward.
Oh, by the way, that $50 million would be on a going forward deal, considered an investment, and give you $50 million of investment. Meaning, if it doesn't go anywhere and we fall out of bed, it's $50 million non-refundable. If we fall in love again, then it would go towards a investment because, that seems rational to me.
Okay.
And, I hate to make it sound like, that's, a demand, but it's a demand, so don't even bother, taking it anywhere if you want to continue down the current path. But don't take it up the chain, without knowledge that it's going to cost $50 million to sit down and get lawyers and get this done. and have a meeting that hopefully goes good for both of us. You know, honestly, I'm the kind of guy who can forget the past quickly.